All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here today on our case 1CA CV16-0773, American Furniture versus Gilbert. Each side will have 20 minutes to present their argument. Appellant, you may save time for rebuttal if you wish. You'll have to manage your own time for that. We have a clock at the podium for that purpose. We are recording the argument in a couple of days. It should be out on YouTube if you want to watch how you did. Because we are recording it, please identify your client and yourself when you begin your argument. We've read the briefs and the record. We've conferenced the case, so we're familiar with the case. So when you begin your argument, just go right to what you think we need to know. Counsel, you may begin.
Good morning. May it please the court. My name is Jeffrey Gross with the law firm of Berry Riddell. I'm representing America Furniture Warehouse, which I'll refer to as AFW in my comments. And with me at council chambers is Martin Aronson, my partner at Berry Riddell. We are here because the trial court found as a matter of law that the assessment that the town's traffic signal impact fee, the assessment of the town's signal impact fee against AFW was a legislative act that was entitled to a presumption of validity. That's, as far as I'm concerned, the main issue that I'd like to focus on. And as a result of that determination, the trial court rejected our contention that Dolan versus the city of Tigard established a test to be applied to that assessment, and our alternative contention that we were entitled to an exaction appeals hearing pursuant to ARS section 12-500.12. I'm sorry, 9-500.12. These decisions were wrong. The focus of the trial court ruling, even though it's only one or two sentences, and as the focus of the town's argument as well, has been on the reasonableness of the ordinance that establishes the categories and the charges for the traffic signal impact fee, not the assessment as it applies to AFW's use. And that's what I want to focus on today. The central facts regarding that issue are that the town required AFW to pay a fee, $1 million fee, in return for issuance of a building permit to build its project. That payment was a condition for AFW to develop its property. Those are undisputed. And the town, in looking at the application of its ordinance, which established categories of the fee and per square foot charges of the fee, determined that AFW's entire use was retail and charged the retail rate for the entire building. Those are the facts. Those are undisputed. A central issue for that on the appeal is whether the town's assessment was adjudicative, which would implicate the Dolan versus City of Tigard test, and subject the assessment itself to a Dolan challenge using the rough proportionality test. And incidentally, because the statute is sort of framed on the Nolan-Dolan type of test, would allow us to appeal under 9-500.12. The town argues, really simply, that the official who determined the fee, who assessed the fee, determined it correctly, determined that the entire use was retail, and that he had no discretion to do anything else. And the reason for this is a circular argument that the town official had no discretion to determine that a retail use was anything other than retail. But that circular, it misses the point. It misses the point because under Dolan, we agree, I think we all agree, that this was what's ordinarily called in this land use context an exaction. It's an exaction. We all agree on that. It's a condition imposed against a property owner in return for an approval to use property. In this case, it's a building permit. It's an exaction. In the realm of exactions, under the unconstitutional conditions doctrine that was established in Dolan and reaffirmed in Kuntz, and or under the statute for that matter, an exaction has to be roughly proportional, or in terms of the statute uses, have a reasonable relationship to the impact or the needs created by the development. That analysis has to be made. And the city bears the burden. There's no presumption of validity. The city bears the burden to make that determination. And the city has to base that determination on some sort of individualized analysis. It doesn't have to be perfect. It doesn't have to be a perfect fit, but some sort of individualized analysis of whether the fee, in this case, or the dedication or the exaction bears that rough proportionality to the needs created by the development. So that's...
Counsel, does that calculation in and of itself make this adjudicative?
It's a tough word to say. The calculation itself can, in this case, in this case, it's the determination. I think it's a bigger picture, if I'm understanding your question right.
The difference between the legislative and the
Yes.
adjudicative is the responsibility of the
Yes.
administrative
Absolutely.
to make certain decisions that may or may not impact the cost to the
Yes,
developer.
and that's where I was going. Yes, in that case, absolutely. And in fact, in a case which we may talk about later, Home Builders versus City of Scottsdale, this court said that the critical determining factor in deciding which of those two decisions has been made is the amount of adjudicative staff level discretion permitted by the ordinance. Now, we have gone through in the briefs to, I think, explain in detail why the ordinance, in this case, because we're not challenging the validity of the ordinance, we're challenging the assessment, we're challenging the way that the ordinance was applied to AFW, why the assessment is adjudicative. And that's really, to summarize, the reason is that the ordinance gives little or no legislative guidance to the town official. It just says there's these three categories. There's retail, there's office, there's industrial, and then there's other non-residential.
And if those categories were defined by ordinance, would we have a different outcome?
We may. If they were defined somehow, if there were examples given, if there were guidelines given, we may have a different case. For example, let's compare this case to the City of Scottsdale versus the Home Builders case. In that case, the legislative scheme said the developer is going to pay $1,000 per single-family home as a water development fee. A developer who's developing multifamily, well, that's not single-family, it's multifamily, we know what that is going to pay $600 per unit for a water development fee. Again, those two things are set in stone. There's concrete. There's no discretion. There's no interpretation. And all other uses, every other use, you don't have to decide whether it's retail, whether it's office, whether it's industrial, pays $2,000 per estimated acre foot of water usage. Those things are very, again, set in stone. They're concrete. They don't allow for interpretation.
But
here,
Counsel, let me ask you, and I understand what you're saying, and City of Scottsdale is a different case than this one, but estimated water usage, that strikes me as sort of at the core of what might be adjudicative as opposed to legislative. And what I guess I wanted to follow up on Judge Jones' question, under Dolan, if applicable, the rough proportionality standard for adjudicative things. And there's a statutory right for an administrative hearing, by contrast, if there is discretion in the application of the ordinance. But I guess what I want to make sure is your argument it has to be one or the other always for an ordinance to apply? Or could you see a world where an ordinance would be so specific but not too complicated where it would violate neither of those or implicate neither of those?
Implicate neither of?
Dolan?
Yes.
Or the discretionary aspect of the statutory right for an administrative. In other words, one way to hear your argument is, look, there always has to be an evidentiary, sort of adversary proceeding or a court proceeding anytime any fee is assessed for a development. And I don't know that squares with my understanding of current law.
I think I can answer that question two ways. First of all,
and this is far broader than the specific case, so I'm
right.
I'm looking a little further down the road.
I think and again, I think we have an election of remedies here. We can go to court and challenge the constitutionality of the fee, or we can go to the exaction appeals statute and go that administrative quasi-judicial route, right?
You've attempted to do both.
Yes, we have. We've tried to keep our options open. I think the statute very clearly gives the right to anyone to, as long as it's not if there's a legislative act that gives some discretion to administrative officials, then every time that that act is done, then there's recourse to a quasi-judicial body, and then ultimately to court.
And I appreciate that concluding sort of clarification. But can you, and because I heard you, I thought, say that City of Scottsdale might present a situation where there wasn't discretion. I pushed back somewhat.
Oh, yeah.
But can you envision a world where there would be a case where there would be no discretion, and you wouldn't have a right to an administrative appeal? In other words, are you arguing there always has to be either a constitutional challenge, you can go straight to the Superior Court or otherwise, or an administrative appeal, and there's nothing else? That's the universe.
Yes, I think that's what I'm arguing. Subject to one, we do have this issue about whether only adjudicative acts are subject to the Dolan requirement, or whether all adjudicative acts and legislative acts are subject to the Dolan requirement.
And I appreciate that, and I'm not, believe me, by my question asking you, because I hear you taking that position in the briefs, and I'm not suggesting you're waiving that position, but if the world, the Dolan, City of Scottsdale, Kuntz world used that distinction, your position is you would still always have that statutory right, even for non-adjudicative determination.
Yes, ultimately, at the end of the day, I believe that it should be fair. It should be the law that whether it's adjudicative, whether it's legislative, I don't know that there's a third option, but either in those cases, the city shouldn't be able to insulate an unconstitutional condition from judicial review one way or another.
Well, but that sort of assumes that it's unconstitutional, and that's why I'm pressing you a little bit. So is it every development fee of any type would always be challengeable either as a unjust or a constitutional taking or administratively? That's your point of view.
If there is, sure. I mean, if there are legal grounds to challenge the assessment of a development fee or an exaction or a dedication to a particular project, just like any other legal grounds. If there are good faith legal grounds for taking the position that what the city is doing to me is contrary to Dolan, I apologize if I'm not understanding if what the city's doing to me is unconstitutional, then I have a right to seek judicial review of that.
My question on the administrative side was somewhat different. It is really, your position is that there is no ordinance that could be so discretionless, if you will, that you couldn't make an administrative challenge, regardless of the quantity of the fee, regardless of the ordinance applied.
I suppose in a perfect world, there could be a way of drafting an ordinance that would remove all discretion and define use or the way of assessing the fees precisely enough that it would remove most or all judicial challenges. I mean, if the city said, okay, here's how we're going to define retail, and here's exactly how we're going to determine the rate, and for every piece of property in the city, here's how we're going to determine the assessment. We're going to use traffic counts for roadways. We're going to use customer counts for determining how much to charge for police development fee. Or we're going to use this measure for determining if you have to dedicate a roadway to us. Then yes, if they make it specific enough, then I suppose that they could remove most or all judicial challenges. So just really quick in wrapping up on the Dolan issue, we believe that we've presented facts, not facts that would lead the court or should have led the trial court to determine that what the town did was adjudicative, and we should have got to either an exaction appeal permitted or been able to go forward and apply the Dolan test. And if we had applied the Dolan test, then there were enough facts, and we've listed them in the briefs, enough facts to get to the jury on the issue of whether the $1 million fee, given the impact of AFW's project on the traffic signal system, was roughly proportional to the needs created by it. And I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel. Counsel?
May it please the court. My name is Kim Alvarado. I'm an attorney for the town of Gilbert with the Grosso Law Firm. And with me at council table is Chris Payne. He is the Gilbert town attorney. Council made the point that we've been trying to make in our brief, which is to adopt American Furniture Warehouse's argument means that superior courts are going to be holding trials every time a municipality assesses a system development fee, which is set forth in Section 9. That can't be the law, Title 9. That can't be the law in Arizona. Certainly we don't see these trials all the time. And the City of Scottsdale case, Scottsdale 3, was decided in 1997. AFW is working very, very hard to avoid Scottsdale 3 because essentially decides the issue. Scottsdale 3 is directly on point. It dealt with system development fees. It dealt with Title 9-463.05, and it basically laid out the framework for how those cases are decided. And since then, of course, all cities and towns in Arizona have followed that guidance and have adopted their statutes in reliance both on that guidance as well as the statutes. And so that's exactly what the town did here. They have a very comprehensive study. They have an infrastructure plan. They have a capital improvement plan. And all these different fees and rates were set forth based on these statutes. What American Furniture Warehouse is really arguing for is that they almost want more specificity drilled into these legislative acts that have to have general applicability.
Well, it seems like the four categories really aren't defined, and it's up to the city in its discussion which category of particular entity falls under.
Well, the ARS statutes don't define those either. I think it's because they're so obvious. I mean,
Well, counsel, are they that obvious? If you've got a building that's 3/4 warehouse and construction area, and yet you say that 100% of the building is retail? I mean, doesn't that kind of leave to the discretion of the city of Gilbert how they're going to define this, and shouldn't that discretion have some element of review?
No.
It's a
First
short
of all,
answer.
yes. 3/4 of this building is not, it's, when you say warehouse and construction. Let's step back for 1 second. Warehouse, it's their fancy term. This is just a very creative marketing for the stockroom. And every single retail store has one. Whenever you go into Home Depot and say, I can't see, there's something on the shelf, they say, I'll go check the back. It's just a stockroom. The men's warehouse also is not a warehouse. It's a men's clothing store. DSW, the discount shoe warehouse, is a shoe store.
But they're not sewing suits in men's warehouse. As I understand it, they're actually building the furniture there as well.
No, they assemble chairs. My understanding is they assemble dining room chairs that are shipped to them from Colorado. Everything else is assembled. That's their business model, and how it differs slightly from IKEA is that you walk through, you say, look at that wonderful entertainment center and the lamp and the chair. I'm going to pick those out. At IKEA, you go down and to the quote warehouse. It's just the stock room. And they put it onto a cart and you buy it, but it's in boxes. At an AFW, you just pull your truck around the back and they load it into your truck and you drive home with it that day.
Does that make the fact that they have a huge inventory on hand?
Correct.
Does that make all the inventory space retail space?
It makes the store a retail development, because everything in that structure and the town's ordinance is based on the structure, not based on how different parts of the square footage within the structure are used. The structure is a retail structure because everything within that structure supports retail sales. They've decided that they want to have all their their inventory on hand so that you can buy it and take it today, as opposed to another furniture store where you have to go in, you have to pick out the upholstery, you have to pick out how you want the wood, and they make it in some other state and you get it in 6 weeks to 8 weeks. Here, that's AFW's sales model.
How would that distinction matter under your view of the ordinance? The hypothetical that you just described, I'm guessing your client would also characterize as retail.
Right.
So
If you're selling to customers, you're selling, retail's like you're selling to on-site customers. That you're selling products, you're selling goods, you're selling services. And regardless of how this current occupant, and it might be different 5 years from now because you might lease it out. However, regardless of how you choose to divide up your space and how big you want your stock room, and if you want your showroom to be bigger, if you want your cafe to be larger, the structure is a retail structure, which is what they told us when they wanted us to sign the retail sales incentive agreement.
How does that, where would I find what you just described in the ordinance?
The definition of retail is not set forth in the ordinance. What's set forth in the ordinance is retail, office, and industrial.
And then there's the miscellaneous other, right? Which
Other non-residential.
Right.
Right. This is clear, as the town engineer testified, I can't call a retail store something that's other than retail. That would be discretionary.
That's a bit of an ipsy-dixit, though, isn't it? I call it retail because I think it's retail.
Because they told us it's retail.
And
Because AFW told us they're retail.
did they tell you the whole thing was retail, or did they tell you that they were conducting some retail activities out of the development?
They've always taken the position this is a retail development. That was what was set forth in their application. They asked for the entire area to be rezoned from industrial to regional commercial, and it was. And they always try to say, we have a showroom and we have a warehouse. Again, that's just their business model of how they design their store. Lots of other stores could do it differently.
Isn't it common for developments to be planned and effectuated in the context of a regulatory environment? I mean, I guess I don't understand what your point is in that respect.
The point about, I mean, certainly they knew that the ordinance was obviously out in the books. They obviously knew what the calculation was going to be well in advance. And of course, when the estimate of the fees came out, which if you notice, it was about $1.9 million for everything. That's where, again, the town doesn't have any discretion on that because those are all set by ordinance. But there where they do have discretion is then doing these incentive agreements, and they were basically going to reimburse AFW up to $2 million through the incentive agreement.
So you or the city's view is that it is so obvious what retail is, it's so obvious what office or industrial is that they don't need to be different because we all know what they are?
We all know what they are, and in this case, American Furniture Warehouse told us what they are. They told us it's a store. They told us that they needed their property rezoned from industrial to commercial because this is a store. Regardless of how they choose to use different areas within their store for offices, for a cafe, for a showroom, for the stock room, it's still a store. And every use within that building supports retail sales.
Well, but if you, and I realize you say that this isn't what American furniture does, but if they actually manufactured the furniture from the wood, if they had wood delivered and they actually built the furniture there and then they sold it, that manufacturing, that industrial part would be in support of the retail part of it.
Well, that's true, but that would be a completely different case because I think in that case the zoning would be different. And obviously with the zoning comes issues about parking, and here you have to have so many parking spaces based on the customers you're going to have. Here they actually had to put in a traffic signal because this store is so large that they had to have a dedicated traffic signal just for cars turning in there.
But
and that's a different case that you're talking about.
If they sold as much furniture, whether it was, even if it was actually built on the property, it would still be the same situation. You still have the same traffic, you still have the same need for the traffic signal, but you might charge that as industrial rather than retail, depending on the discretion of your city official.
Yeah, I mean, again, I'm not an expert in zoning laws because I'm thinking if you're actually building and manufacturing furniture in a plant where you have equipment and all that stuff, I think that's going to have to be in a different zoning area than in a regional commercial zone for this large store that's right off the freeway. Most, obviously, industrial plants and manufacturing areas are not right off the freeway. And here it was extremely important to American Furniture Warehouse that they wanted visibility off the freeway. That was one of their driving forces in choosing the location that they did because they wanted everyone to see them. And they wanted retail customers to see them where they are.
Counsel, you've mentioned a few times the rezoning to commercial.
Correct.
And I understand that, but that's not a phrase used in the ordinance to differentiate these fees.
I understand that, but when the question was, how does the town know that this is retail? What I'm saying is it's because that's what AFW told us they were. They wanted to operate their store in a commercial area.
Well, I understand that point, but with the rezoning, is only use for commercial rezoning under the town retail, or could that be office as well?
I don't know enough about the town's zoning laws to answer that question accurately. I mean, I don't know if commercial retail could also be office. I'm not sure.
Okay.
But I know here it was industrial, and they asked for it to be rezoned to commercial regional so they could build their large store there, what they call one of America's largest furniture stores. I mean, here the square footage, the fee that's assessed is based on the two things that they told us, which is we're a store and this is our square footage. And from that point, it's just a mathematical equation. What they're suggesting is literally any time administrative officials here take an ordinance that basically has already done the work and has the formula in it and takes the information that the applicant is giving you and says, we're a store and here's our square footage, and we simply do that calculation, that's going to and create an exaction appeal and a challenge every time.
This per square foot charges under retail, office, and industrial were based, as I understand it, on some studies, something like that?
Right,
Is that fair?
correct.
And those were then promulgated as discrete units. So in other words, there's a certain number for retail, a certain number for office, a certain number for industrial. How would that study support those numbers for a mixed-use building?
Well, they didn't. I mean, they never, I don't know if they could be interpreted that way, but the town did not adopt any basis to apply a mixed-use blended rate, any type of assessment based on that point.
Are you saying in this case or in regard to their ordinances generally?
In regard to the town code on system development fees, they did not adopt a blended rate mixed-use calculation.
So they exercise their discretion not to do that?
No, when the town council adopted, or basically wrote and adopted the ordinance, that ordinance, and it was based off of their capital improvement plan and their infrastructure improvement plan, and then this, what we call the Gardenia study. They took all those things, there's planning commissions and obviously all that. They wrote the ordinance, and they went with categories of residential, office, and industrial, as opposed to what council was suggesting in Scottsdale 3. They just went single family, multifamily, and all other uses, even bigger categories. I mean, here Gilbert was trying to be somewhat more specific because based on their Gardenia study, they were saying that retail obviously generates more traffic than other forms, and that's pretty obvious. We'd all understand that.
But Council, I think whether it's single family or multifamily is pretty plainly known. Either one family lives there or more than one family lives there. There's not much discretion there. But if you would take an example where you really would have a building that was one through retail, one through office, one through industrial, how would the city of Gilbert apply the statute in that situation? I realize you're arguing that's not the case here.
No, it's not that. That's not this case.
But what if it were the case?
I mean, I'm trying to envision if there's a strip mall that has a dentist office and has a Dunkin' Donuts in the same strip mall. The answer, I don't know the answer to that. I don't know how they've done it in the past. I know there wasn't any discovery on that in this case. All I know is in this case, AFW is making an as-applied challenge to them.
But wouldn't it be up to the discretion of the appropriate city official to figure out, well, I know what's wanted and what they wanted, but I really think this is retail. I really think this is industrial.
Well,
it would be
again,
up to the discretion of the official.
Well, again, I think it depends on what the applicant tells the town when they're applying.
That's the case then. Let's say you get the same application for the same use and it says, you know what, this is office space. We're selling a little bit of stuff out the back, but it's office space. Does that mean the city or the town is bound by that and that you'd assess it at 57 cents a square foot instead of $1.59?
Well, I certainly don't think the town would be bound by it, but I certainly think it would be good information, and it would certainly be evidence in the record to support, in this case, the town engineer's decision and ultimately the town manager's decision or the denial of the written protest here.
Then they would have the discretion to disregard that information or to say, yeah, I know they say it's office and they only sell a little out the back, but they're really selling. And I know that's what they said, but in our discussion, we really think it's retail.
Well, I think that they have to look at the evidence. I mean, keep in mind, in these contexts, the building officials and the applicants are in discussion constantly. This isn't sort of you send in a form and you never hear from them again, especially for a facility as large as American Furniture Warehouse. There's ongoing meetings and discussions and lots of information coming out.
Yeah, but you just said they have to take in the evidence. Isn't considering evidence the ultimate discretionary determination? They have things to weigh.
No, it's ministerial, because here they're taking the information provided to them and then they're applying the town's formula.
But you just said they can not follow that information if it doesn't turn out that
Well,
way.
I mean, if the applicant was being disingenuous or trying to
Yes.
give bad information so they could just pay less, I mean, we'd have to see what the actual information, what the facts are.
I mean, the city official would have the right to disregard that then in that circumstance.
I think in having to apply the legislative ordinance in this case, which is what they have to apply, I don't think they can just, park their brain at the door and say, well, he told me it's an office, even though I know it's American Furniture Warehouse and they're generating $7 million a month in retail sales to customers that are driving up.
But that's more than a ministerial act then.
No, I think it is a ministerial act, because again, you're taking the information that they're giving you throughout the entire planning process, but you're also looking at what the facility is. The assessment in this case, I think AFW is trying to drill it down too narrowly when they're trying to fall within the exception of the statute to get an exaction hearing. What the Dolan and the Nolan cases we're talking about is when someone is coming in, and wanting to get a permit, and in those cases it was like, before we give you your permit to build your bungalow, we want you to give us an easement across your property. Or even in the Coons case, it was even worse.
That's true, but that's on a constitutional basis,
Right.
not applying Arizona's statute.
Right, and in reaction to those cases, and in reaction to the Coons case, where it was, you can develop your property as long as you build on our property a couple miles away and you help with the stormwater over there. What those cases talked about, and then what Scottsdale 3 talked about in 1997 was, look, if the municipalities just enact these ordinances for system development fees in compliance with the ARS, then this whole analysis doesn't apply, because
Did they
those
say
are
that?
generally
Or
applicable
did they say
legislative acts.
there's no constitutional claim that there was a taking without unjust enrichment? Let me ask you differently. Let's say Dolan and City of Scottsdale and Kuntz don't exist. It's just the statute. I don't think that means the case is resolved. I think we then are asked to apply the statute.
Right. Yeah. Yes, I would agree with that. But, well, I'm not sure I would agree with that, because, I mean, clearly the other statute says that Dolan and Nolan are part of the test that the legislature established in 9-463.
But they put two subparts in, and we're not. That suggests to me that they meant something slightly different in each.
Are you talking about where they have section B for the exaction hearings, and then for? Right, I think they were addressing the situation of what has happened in Dolan and Nolan, and Kuntz, whereas a property owner wants to develop their property, and the town is imposing some individualized condition on them, as opposed to, again, so that you give me an easement across your property, you go develop that stormwater system over there, as opposed to, we're just assessing a fee based on what an ordinance says, which is system-wide, generally applicable.
But the appeal right turns on whether there's discretion or not, correct? Which is something I think quite different than Dolan and Nolan and City of Scottsdale in their constitutional analysis. Well,
I think I would disagree in the sense that I think the discretion, if you read the entire statute together, that I think it's the section B, is if you read the whole thing in context, it's talking about this does not apply, the exaction hearing does not apply when the exaction or the dedication is pursuant to a generally applicable act for which there's no discretion. I don't think you can say, well, we've met the first part, but we're going to fail this case on the second part. I think.
No, I'm asking you that exact question.
Okay. I think when it's a generally applicable act, an ordinance, a generally applicable legislative act, of course, administrative officials have to apply the act, but they're just doing that in a ministerial context. They're not making decisions based on, I want to give you a break, but I don't want to give him a break. I mean, what American Furniture Warehouse is asking for in this case, and they have throughout, is they're the ones who are injecting all these exceptions and subparts and different readings into this. They first wanted, to have the blended rate, which isn't part of the statute. Then they wanted to say, you know what, you should really differentiate between types of retail, because furniture stores should be treated differently than drugstores, because it's based on the amount of traffic they generate.
Is that atypical for a developer, though? I mean, I understand what you're saying, but I'm not sure how it applies to our analysis here or our appeal. But is that so out of the norm that it should be noted by us?
Well, my point is that the town was trying to apply and I'm out of time.
Oh, please.
The town is trying to apply a generally applicable legislative act across the board. And throughout this case, American Furniture Warehouse has been continually asking for exceptions, and they've been wanting to read more into the ordinance that doesn't exist. Things like furniture stores should be treated differently than drugstores. You should, within the retail category, you should look at trip generation. You should have a blended rate. They keep asking for all these exceptions, and of course the town's position was, we have to enforce this uniformly across the board. It's all retail. So whether you're a niche business that, you sell olive oil imported from Italy versus your CVS, you're going to both be in the retail category. Where it's individualized, of course, is that it's based on your square footage, which is what you as the structure owner has determined. But, is what happened in this case, the town is able to work with American Furniture Warehouse to develop an agreement, a retail development agreement, where essentially they reimbursed them for all the fees that they had that were imposed, but those were fees that were imposed by statute for which they couldn't make exceptions.
Thank you, Council. Any further questions? Thank you, Council.
Thank
we
you.
appreciate your argument. Council?
Thank you. Just a couple of clarifications. First of all, Council described our AFW's use as basically a self-contained retail store with everything that going on in the store aimed at the retail use, the retail components. That's not true. That's not what the record reflects. The record reflects that this was a showroom plus a 400,000 square foot warehouse that was designed not only to house furniture for the storeroom, but for satellite stores that are in the process of being built or will be built in the future for offline customers. There's 50 loading docks that are designed around the warehouse so that this warehouse can function as a truly regional facility. So it's not all associated with internal retail sales, but even so, there's still the discretion. It still comes down to the amount of discretion. What if our showroom had 4 couches, a coffee table, and an easy chair? And the folks could come in and say, well, I like this couch. I like the easy chair. Can you make it red instead of black? And the showroom were literally 200 square feet. Does that then make the entire facility retail?
Well, Council, haven't we been told that what defines retail is what you put on your application?
That's what you have been told, and that contention also is false.
Because?
Because the application, everything that was submitted, and we run through this in the brief and bullet points, everything that was submitted to the town said retail and warehouse, described this regional warehouse. One of the things that I think is most telling is that they used, the town official who made the decision that this was going to be retail, used building plans that had occupancy codes from the International Building Code on them. Yes, mercantile for the retail portion, the showroom portion, which the town official then said, okay, mercantile, that equals retail. But also, which he ignored, a bigger code for storage and a bigger code for factory. I'm sorry, not a bigger code, a smaller code for factory. So there were 3 codes. There was mercantile, there was storage, there was factory. He ignored storage and factory.
Counsel, I got a question for
Yeah.
you, which probably doesn't surprise you a bit. But if you look at a self-storage facility, they've got an office up front, and they've got rows upon rows, a couple of acres of small storage units that people rent. Does that make them retail entirely? Would that, in your assessment, make them something other than retail? Maybe that's a bad example.
I'm not familiar enough with how self-storage operates, but
you understand what I'm saying?
Yeah, I understand.
You're not retailing out of the larger, and it's the issue I raised with your opposing counsel. My recollection of looking at those plans that were in the briefs were that the warehouse area, or whatever you want to call it, the area where they construct the furniture, was 2.5 times what the retail space was, or it's vastly larger.
Vastly larger.
And yet, no one walked in and said, "Oh, look, it's a warehouse or an industrial area, however you want to call it, with a small retail area." They said, "This is a retail shop." Now I hear it's because your application said it's a retail store. Do you have the ability to then go in and say, my mistake, my bad, we really should have said it's really just a warehouse and we have a small amount of retail? Would that have made a difference here? And that's where I was getting to the self-storage issue.
Well, first of all, it wouldn't have made a difference because that's exactly what we submitted. That's what the record shows was submitted. Plans and an application that says it's going to be warehouse and retail. So now, if it were, I'm sorry.
No, go ahead.
I was going to say in your self-storage example, if there was a little office component where, the person who took the money.
All the business is done.
All the business is done? Okay, fine. Maybe that is not separate and apart from the retail. Maybe it is. It depends upon what the other uses of the retail might be, or the other uses of the office might be. But kind of getting back to the main point, that doesn't necessarily mean that the person who is deciding what that use is lacks discretion.
So they could have walked. Let's put it this way: in regard to the issue of discretion, did anyone from the city ever come in and say, "Look, I know you wrote down retail here, but 2/3 of this is warehouse," and so did anybody do that with you?
No, because that's not the facts. Nothing was submitted to the town that said this is all going to be retail. That's just a false statement of the record. It didn't happen. So nobody would have done that.
Thank you, Counsel. We appreciate your arguments today. We'll take this matter under advisement and issue our decision in due course. We stand adjourned.